This video is about analyzing the legal nature of human rights in England. Human rights in England are composed of a bundle of laws. These are the European Constitution of Human Rights, Human Rights Act 1998, and European Case Law. The European Convention of Human Rights was created in 1950. However, it was not incorporated into UK law until 1953. Therefore, Parliament could restrict civil rights by passing legislation. The European Convention of Human Rights was incorporated into UK law by creating Human Rights Act 1998, which states that everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind. Furthermore, no distinction shall be made on the basis of the political, jurisdictional or international status of the country or territory to which a person belongs, whether it be independent, trust, non-self-governing, or under any other limitation of sovereignty. According to Keenan and Riches 2007, the Human Rights Act 1998 enables people to enforce their convention rights in UK courts rather than having to exhaust all domestic remedies before bringing a case to the European Court of Human Rights in Strasbourg.
This Act incorporates and enforces the main articles from the European Convention of Human Rights, which are Article 2, the right to life, Article 3, prohibition on torture, Article 4, prohibition on slavery and forced labor, Article 5, right to liberty and security, Article 6, right to fair trial, Article 7, no punishment without law, Article 8, right to respect private and family life, Article 9, freedom of thought, conscience and religion, Article 10, right of freedom of expression, Article 11, freedom of assembly and association, Article 12, right to marry and found a family, Article 14, prohibition on discrimination. Protocol 1, Section 1, the right to peaceful enjoyment of one's possession. Section 2, the right to education. Section 3, the right to free election. Protocol 6, Section 1, abolition of the death penalty. Section 2, death penalty in times of war.
To classify human rights, we need to establish if it's a civil or criminal law. According to Section 6 of Human Rights Act 1998, it is unlawful for a public authority to act in a way which is incompatible with the convention rights. This means that human rights have no horizontal direct effect, and you can bring the proceeding only against a public body. Therefore, the Human Rights Act 1998 is a part of a public law. In the event of a breach of Human Rights Act 1998, the victim is able to take proceeding to High Court. If the verdict, however, will not be satisfactory for the victim, there is a possibility to take it further to Court of Appeal, the House of Lords, and then to the European Court of Human Rights. According to the UK's constitution, Parliament is supreme. This has resulted in several cases where if the court is satisfied that the provision is incompatible with the convention right, it may make a declaration of incompatibility.
The case of Halford versus United Kingdom 1997 can be used as an example of a situation where breach of human rights has taken place. Miss Halford was employed by the Merseyside Police. However, following a refusal to promote her, Miss Halford commenced proceedings in the Industrial Tribunal against her employer, claiming that she had been discriminated against. However, during the proceedings, Miss Halford claimed that calls made from her home and her office telephones were intercepted for the purposes of obtaining information to be used against her in the discrimination proceedings. The issue in the case of Halford versus United Kingdom was whether her human rights were breached by the police or whether they had a right to monitor her calls. According to Article 8 of the Human Rights Act 1998, everyone has the right to respect for his private and family life, his home and his correspondence. It is unlawful for public authorities to act in a way which is incompatible with a convention right. The court observed that the telephone calls may be covered by notions of private life and correspondence. According to the Netherlands Institute of Human Rights 2009, she would have had a reasonable expectation of privacy for such calls. Furthermore, she had been given the assurance by her employer that she could use her office telephones for the purpose of her sex discrimination case. For these reasons, the court concluded that the telephone calls made by Miss Halford fell within the scope of the notions of private life and correspondence, and that Article 8 was therefore applicable to this part of the complaint.
As mentioned before, the victim can take the proceedings to the 3 courts within the UK. The example of such case is Campbell v. Daily Mirror, where Naomi Campbell sued the publisher of Daily Mirror for breach of confidence, invasion of privacy, and breach of the UK's Data Protection Act after the Daily Mirror published the photographs along with a generally positive article about her attendance at Narcotics Anonymous meetings. Miss Campbell was awarded £3,500 by Morland J. However, the case went to Court of Appeal, where it was dismissed, and Campbell was ordered to pay the cost of trial and 80% of the costs of appeal. The case went further to the House of Lords, where Naomi Campbell won the case. To analyse this case, we need to establish if Naomi Campbell has the right to privacy or Daily Mirror has the right to expression. First of all, the court assumed that the newspaper must have known that the information about the model's drug treatment was confidential. However, the Court of Appeal reversed the decision, holding that publication of Campbell's confidential information was justifiable in the public interest because Campbell had previously publicly stated that she did not use drugs. Even though Campbell did not bring her case under the Human Rights Act, the Lords said that in this instance, Campbell's right to privacy under Article 8, as protected by the breach of confidence action, outweighed the Daily Mirror right to freedom of expression under Article 10. Article 10 of the Human Rights Act 1998 states that everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Therefore, the House of Lords ruled that Miss Campbell has the right to privacy.
In conclusion, the Human Rights Act 1998 is a public law which gives rights to every person in the UK. Failure to comply with this law can result in the accused public body being taken to court by the victim, such as in the cases mentioned of Halford versus United Kingdom and Campbell versus the Daily Mirror. The Human Rights Act 1998 is thus an obligation to not act against the European Convention of Human Rights.